Okay, we'll call ourselves back to order. Let's see, we've been commissioner questions. I think, let me just ask one, Mr. Karen. We'll go back to Mr. O'Donnell's. Table 9 on page 48, I'm looking at. He calculates a ratio of coal ash AROs versus kilowatt hours of coal generation for each utility. And my question is just, you know, Duke Progress and Duke Carolinas are up at the top. Why are Duke's ratio so much higher than the other utilities around the nation?
I think it's severalfold. One, we're much farther ahead than other utilities. So our numbers are based on our plans moving forward. They're very detailed estimates. We have contracts in place. So we're quite a bit farther ahead than others. Others, and I talked to my peers, they're still doing their investigation. They haven't decided how they're going to close yet or how they're going to get approval through their state agencies. So they're using some very general cost assumptions in their ARO, where ours are very specific, management approved. Our independent auditor reviews and approves it. So it's gone through a pretty detailed scrutinization.
Okay. Thank you. Commissioners, any other questions? Any redirect?
Just a few, sir. Mr. Karen, Commissioner Hamilton asked you some questions about insurance litigation.
Just make sure your microphone's on.
Mr. Karen, Commissioner Hamilton asked you some questions about some pending insurance litigation that's going on, and you testified that you don't recall the specific amounts, but do you agree or disagree with me that the claims and questions are in the hundreds of millions of dollars, not just several dollars?
I believe they're in the hundreds of millions of dollars.
And if the company is successful in obtaining any money under any of those claims, is it your understanding that that money will go directly back to customers, or is the company going to keep that money?
My understanding, it would be going to the customers.
Now, Mr. Karen, Commissioner Hamilton was also talking to you about selling ash for beneficial reuse, and you used two different terms there. I heard you say beneficial reuse, and then I heard you use beneficiation. Now, am I correct that beneficial reuse, like we're doing at the W.S. Lee site, to sell unprocessed ash to the cement kilns down here in South Carolina, that's where you dig it up out of the ground, you shake it for rocks, and you just put it on a truck. Is that right?
That's correct.
When you say beneficiation, that's the thing that CAMA made you do, right?
Yes, such as the buck plant.
Okay, and that's where you put it in that machine you testified to, that STAR machine coming out of South Carolina?
That is correct.
Okay, and that's the stuff that's more valuable that you testified you're selling to the ready mix market?
Yes, because it meets all their specs, and they can use it in lieu of a portion of their Portland cement.
I see. Now, Mr. Karen, if you'd go to your rebuttal testimony for me on page 14.
I'm there.
Okay. If you look at lines, just to orient you, lines 15, starting at line 15, counsel for ORS was asking you about the cost to beneficiate under CAMA. Remember that?
Yes, sir.
And you had testified that under a 2029 date, you thought it'd be somewhere in around about $500 million for accounting purposes when you put that on the ARO?
I believe that's correct, yes.
Right. Well, read for me what you say there on line 15, starting with for the buck site. Page 14, line 15. You see it right there? It says for the buck site.
The buck site estimated beneficiation costs are approximately $131 million more expensive than closure without beneficiation on a total system basis.
Okay. Now, that $131 million, is that the 2035 number you were talking about that you think is more realistic?
I think that 131 number is if we would have capped the basin.
Okay. Now, if another thing, you talk about a system basis. I don't understand necessarily what that means, but I think if I've got it right, that the whole amount of money, when you talk about these numbers like $570 million or $131 million, that's not what South Carolina customers are going to pay, right? They're going to only pay a percentage of that. Do I have that right?
I believe you do, yes.
And for DEC, do you know if it's somewhere around 24%, something like that?
I don't know the exact number, but that sounds about right.
Okay. Thank you, sir.
Thank you. Any recross?
None from ORS.
Thank you. All right, gentlemen, thank you for your testimony, and you may step down and you are excused. Okay, next we are going to whom? Mr. Nelson?
I believe we're going to Mr. Whitliff as next.
Okay.
I do.
Before we get started, I did have some housekeeping issues because I know that y'all had asked us to bring copies of all exhibits with us. Do you want that introduced with each witness that comes up? Can we just give you a stack of those at the end of the day today, or what? How does the commission want to receive this?
I think we can do them at the end of the day. You're just going to enter them, get them entered.
We have a huge box full of exhibits down here, and we'll offer all those. If y'all will remind me, I would appreciate it. Secondly, we also had two, and this kind of messed up with who's going when, but we had two witnesses who we had verified stipulated testimony. That's Matthew Schellinger and Anthony Sandinato. And if it's convenient to put them in at this point, I would ask that the testimony and exhibits of both Mr. Schellinger and Mr. Sandinato be read into the record, and their exhibits entered as the next hearing exhibits.
Okay, then Mr. Anthony Sandinato and Mr. Matthew Schellinger, their pre-filed testimony will be, or stipulated testimony, will be read into the record as given orally from the stand. And their exhibits, do you want to do their exhibits together or separately?
I prefer that they be separate.
All right, Mr. Sandinato's exhibits will be hearing exhibit number 31. Mr. Schellinger will be exhibit number 32.
Mr. Whitliff, could you please state your full name and occupation for the commission?
I'm Dan Whitliff, Managing Director of Environmental Services for GDS Associates in Austin, Texas.
And are you the same Dan Whitliff who pre-filed 40 pages of direct testimony in docket 2018-319E on February 26th of this year?
Yes.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
No.
And if I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes.
Or else ask the pre-filed direct testimony of Mr. Whitliff be read into the record as if given orally from the stand.
Mr. Whitliff's pre-filed direct testimony will be read into the record as though given orally from the stand.
Mr. Whitliff, did you also file as an attachment to your direct testimony a series of exhibits marked as DJW1 through DJW 9.3?
Yes.
Do you have any changes, edits, or corrections to any of those exhibits?
Yes, I do.
Would you please go ahead and read them into the record for us?
I have two changes to my exhibits. On page 2 of the exhibit list, please strike exhibit DJW 4.1, DJW 4.2, and DJW 4.3. And on exhibit 4.7, the effective date of the federal CCR rules should be changed from 10/06/2016 to 10/19/2015.
And just to clarify, Mr. Whitliff, those three exhibits that you asked to be struck from your exhibit list, that's just because there are no such exhibits, isn't that true? I mean,
Yes.
you did not produce them as part of your testimony.
No.
Okay. Mr. Chairman, ORS asks that exhibits DJW1 through DJW 9.3 as amended from the stand be marked for identification, entered in the record of this case as the next composite hearing exhibit.
Okay, these exhibits DJW1 through 9.3 amended as we've just done will be marked and entered into the record as exhibit number 33.
Thank you, Mr. Chairman. Mr. Whitliff, did you also prepare 9 pages of surrebuttal testimony in this docket, which you filed with the Commission on March the 19th?
Yes,
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
I do. I have 2 changes to my surrebuttal testimony. On page 9, on page 9, line 5, strike the word no. On page 9, line 14, strike the word only and replace it with the word primarily. The line now reads, the federal CCR rules and these protections accrue primarily to the benefit of North Carolina.
Thank you, Mr. Whitliff. And for the Commission, we will file an errata sheet on those subsequent to the hearing. Did you also prepare 2 exhibits, Mr. Whitliff, to your surrebuttal testimony, which were marked as surrebuttal exhibits DJW1 and DJW2?
Yes.
And do you have any changes, edits, or corrections to those exhibits?
No.
ORS, Mr. Chairman, I ask that surrebuttal exhibits DJW1 and DJW2 be entered in the record of this case as the next composite hearing exhibit.
The surrebuttal exhibits DJ1 and 2 will be entered into the record as hearing exhibit number 34.
Thank you, Mr. Chairman. Mr. Whitliff, have you ever testified before the South Carolina Public Service Commission?
No, sir.
Okay, since this is your first time appearing here, can you give the Commission a brief synopsis of your educational background and work experience in the area of utility regulation?
I graduated from,
Hang on one second. I just wanted to make sure. I know we're going to have something additional filed, but I don't think we entered the surrebuttal. Do we want to wait to enter the surrebuttal testimony?
Surrebuttal testimony,
Yeah.
I'll just ask that be read into the record as if given orally, as amended from the stand.
Okay. The surrebuttal testimony of Mr. Whitliff will be entered into the record as amended, as though given orally from the stand.
Thank you very
Thank
much,
you.
Mr. Chairman. Appreciate it.
Sorry about that. Continue.
Mr. Whitliff, again, could you briefly give the Commission a synopsis of your educational background and experience?
I have a bachelor's degree in mechanical engineering from Southern Methodist University and a master's in business administration from the University of Oklahoma. I'm a licensed professional engineer, licensed to practice in Texas, Tennessee, and South Carolina. I've been a licensed professional engineer since 1980. I'm also a board-certified environmental engineer with the American Academy of Environmental Engineers and Scientists, where I served as a trustee from 2010 to 2015. I'm a past president of the Texas Society of Professional Engineers and a past president of the National Society of Professional Engineers, where I currently chair the Committee on Policy and Advocacy, which basically promotes and positions of interest to professional engineers around the country. My career in power began in 1981 when I went to work for West Texas Utilities Company as a results engineer, and I held different positions. I was a assistant superintendent. That's the operations supervisor for a gas plant. And I became the power plant engineering supervisor at a coal plant during the startup and initial operations of it. Then became the environmental manager for the utility, where I served before going off to Austin to become the chief engineer of the Texas Natural Resource Conservation Commission. That's the senior technical officer in an organization second in size to the EPA as an environmental regulator. I was there for 4.5 years as the chief engineer, and then I went into consulting I've been with my current employer since 2007. So I think that kind of covers it.
All right. Thank you, Mr. Whitliff. Could you please tell us when you were retained by the ORS and for what purpose?
We were approached and retained in the spring of 2017, but our work didn't actually begin until May of 2017. And our primary role was to answer questions regarding CCR increases to, CAMA increases to CCR cost relative to the Duke Energy Carolinas and Duke Energy Progress.
Thank you, Mr. Whitliff. Did you prepare a summary of your direct and your surrebuttal testimonies?
I did.
Could you please present it for the commission now?
Let's get you a little closer to that mic, too, or point it right at you. It's sort of...
If you'll excuse me just a moment, I'm going to freshen up.
Go for it.
Oh, that's good. Okay. Good afternoon, Mr. Chairman and Commissioners. Thank you for this opportunity to speak to you about the request from Duke Energy Carolinas to recover expenses for activities associated with the coal combustion residuals at 7 power plants in North Carolina and 1 plant in South Carolina. Now, rather than rehash the details of my direct and surrebuttal testimony filed earlier in this matter, I would like to use this time to explain 1, the primary purpose of my review, 2, the underlying principle on which that review was based, 3, the complexities associated with meeting my purpose, and 4, my resulting recommendations regarding disallowances. First, GDS Associates Incorporated, who is my employer, was engaged by ORS to answer a wide array of questions regarding the cost impacts of the company's CCR disposal and remediation activities. More specifically, we were asked to determine the marginal impact of the North Carolina Coal Ash Management Act of 2014 and subsequent amendments on CCR remediation and disposal cost. As you've heard today, that CAMA was passed in good measure to the Dan River spill incident in February of 2014. Second, in accomplishing this purpose, GDS relied upon the South Carolina regulatory context provided by ORS early on in our work. As stated in my direct testimony, I understood, quote, "It is the position of the ORS that costs incurred as a result of jurisdictional laws should not lead to increased costs to the ratepayers outside of that jurisdiction. This matter is addressed in the testimony of ORS witness Seaman Wynn." Third, the cost associated with CCR remediation and closure are affected in material ways by a complex set of court cases, consent agreements, commission decisions, federal rules, state regulations, as well as state laws such as CAMA and its subsequent amendments. Determining with great precision the CCR cost increases above and beyond what the federal CCR rules require, based on the limited information I received during 12 rounds of discovery. I mean, it was a lot of information. It just missed the mark in some cases. Is a bit like performing brain surgery with a pickaxe. That said, I found that the increased CCR cost, CAMA increased CCR-related cost in 3 ways at DEC plants. A, expenditures for plants not covered at all by the CCR rules. Riverbend falls into this category. B, expenditures for closure or excavation options not required under the CCR rules but required under CAMA or North Carolina court decisions. And C, expenditures for actions that would not have been required at this time under the CCR rules but are subject to accelerated schedules under CAMA. Fourth, in quantifying these cost impacts, I relied on information obtained during my site visits to all the plants, my review of relevant state and federal laws and regulations, my evaluation of company responses to data requests relevant to CCR management practices, my review of other documents relevant to CCR management and remediation. Some or all of the expenses sought by DEC for compliance at Buck, Dan River, and River Bend result solely from CAMA and South Carolina ratepayers should not have to pay for increased costs incurred solely as a result of North Carolina laws. Table 5.4 in my direct testimony summarizes what is being sought for recovery. My recommendations for disallowances and the premise on which these recommendations are based. I recommend that the Commission disallow at this time, approximately $470 million of the more than $876 million system-wide in ARO deferrals being requested by the company in this proceeding. Please note that no disallowance is recommended for Allen, Blues Creek, Cliffside, and Marshall, whose closures are not increased as a result of CAMA. In addition, no disallowance was recommended for W.S. Lee, which was closed under a consent agreement with South Carolina DHEC. On the recommended disallowances at River Bend and Buck, I recommend that the company be allowed to resubmit these closures costs when and if the federal CCR rules change to require such action at River Bend or beneficiation as a remediation and closure option for Buck. Additionally, the company should be allowed to recover prudent engineering and planning costs at Buck and Dan River to the extent they were prudently incurred. However, other costs at Dan River are the result of accelerated timelines caused by being designated as a high priority site by CAMA. The company should not be allowed to resubmit for the recovery these additional costs in a future proceeding. This concludes my summary testimony.
I'm going to go back over that last line there, Mr. Whitliff. Is it the company who should be allowed to resubmit recovery for these additional costs in a future proceeding?
I'm sorry. The company should, the way I have written it, and I apologize, the company should be allowed to resubmit for recovery these additional costs in a future proceeding. It just, in my opinion, not ripe at this moment for recovery.
Thank you, sir. Does that conclude your summary?
Yes, sir.
Thank you. Mr. Whitliff is available for questions from the other parties or from the Commission.
Thank you. Company. Make sure you're on.
Hey, Mr. Whitliff, good to see you again.
Right back at you.
Mr. Whitliff, I think you said as much in your opening there, and you agree with me that the ORS has taken the position in this case that costs incurred as a result of jurisdictional laws should not lead to increased costs to ratepayers outside of that jurisdiction, correct?
That's the policy that I was given to work off of.
And you further agree that as it relates to coal ash environmental compliance costs that the company is seeking in this case, the ORS has taken the position that South Carolina customers should not pay for any additional burden that North Carolina law has placed upon them. Isn't that right?
That's the extension of that policy.
Do you understand the ORS's position in this regard?
I think that somebody said it better than I early on in this, is that it seems pretty plain on its face as to what they're saying.
Okay, so you get it, right?
Yes.
Okay. Do you agree with ORS's position in this regard?
It's not my position in this. We were hired to conduct, I want to make sure that I'm clear on this, that our purpose in this was to basically quantify what the cost increases were imposed by CAMA above and beyond the CCR rules. And we had to start from that foundational issue. It's not a matter of whether I agree or disagree with that. That was the starting point for this.
I see. So am I correct, Mr. Whitliff, that it doesn't matter if you agree with something or not? It could be the craziest idea in the world. If you're asked to calculate a disallowance on it, you're going to do it, whether you agree with it or not?
You want to ask that one again?
Well, sure, I'm not trying to be tricky, Mr. Whitliff. If my company tells me to take a position I don't agree with, I'm not going to stand up here and make it. So I'm just asking you, did you agree with the OSRS's position as they told it to you?
That's going back to you here, that's a policy question that I was not asked to address, and I don't have an opinion whether I agree or disagree with it.
Okay. Well, I'll ask you this. You confirmed for me you understand the ORS's position. Let me ask you this.
I do.
Okay. Does this position apply to any jurisdictional law that imposes increased costs to ratepayers outside of the jurisdiction? Or does this position only apply to some smaller subset of jurisdictional laws?
That's a question you'll have to ask the policy person for ORS. That would be Seaman Wynn.
Okay. So you couldn't tell me if the non-jurisdictional law has to be irrational, overreaching, unusual?
Asked and answered. And he's not a policy expert. Mr. Whitliff does not establish ORS policy. He's been hired as an engineering expert to perform calculations.
Sustained.
Okay. Well, isn't it true, Mr. Whitliff, that your position, though, your personal position, is that the company shouldn't recover any incremental cost imposed by CAMA? That has little to do with ORS's position, does it? Your personal position is based on your belief that the company caused
Personal objection. He's asking for a personal opinion from the witness. The witness is hired as an expert witness and is testifying based on the ORS policy as stated to him.
Sustained.
Well, Mr. Whitliff, you state in your surrebuttal testimony on page 5, lines 17 through 19, that had the Dan River incident not occurred, it is entirely reasonable to conclude that compliance at Riverbend would have been limited by the CCR rules, which, as I stated in my direct testimony, currently do not require any action in Riverbend. Did I read that correctly?
Can you tell me the page again?
Page 5, lines 17 through 19. In your surrebuttal, sir.
No, I got it right there.
Did I read that correctly?
Yes. Yes, you did.
And you would agree with me when you say it's entirely reasonable to conclude in that passage I just read, you are engaging in speculation, aren't you?
No, I don't believe I was engaging in speculation. I mean, you may term it that. I was making a reasoned conclusion based on the facts at hand.
Well, Mr. Whitliff, isn't it true that if you knew for sure that Dan River caused the North Carolina CAMA rule, you would have said as much, but you didn't, did you? You said it's entirely reasonable to conclude. Isn't that right?
In my direct testimony, I'm trying to remember exactly where, we included the preamble that was included in an earlier version, I think it was the Senate version of CAMA, that spoke to legislative intent. And I'm not trying here to go back over all of that. My deal is we're here to talk about what were the impacts. The fact is that River Bend was not included as an affected site in the federal CCR rules. The fact that that is being revisited is one of the reasons why I say that while there shouldn't be allowed to recover cost at River Bend at this time, should the rules change, they should be allowed to come back and let's revisit those issues. Right now, River Bend is not an affected facility.
I see. Well, you would agree with me that if the commission finds that anyone's testimony is engaging in speculation, they should ignore that, right? We agree with that?
Say it again.
Yes, sir. If this commission finds, as they read through this various testimony about this issue, that a witness has engaged in speculation, you would agree with me that they should ignore that testimony that's engaging in speculation. Isn't that right?
I think it depends on the source of the expertise of that person. If that's a reasoned conclusion that they can make based on the facts at hand, then I think that it's less speculation and it's more reasoned conclusion.
I see. Well, on page 5 of your rebuttal testimony, lines 1 through 2, you make it pretty clear that DEC should not be allowed to recover for what you call speculative changes to the CCR rule. Isn't that right?
Yes.
So good for the goose, good for the gander, right? We can't do it, you can't either?
I'm trying to figure out exactly what you're trying to get to here. Let's go one more time, just to make sure, because it's important that the commissioners hear my best answer to this, and I want to make sure I'm giving it.
I'll move along, Mr. Whitlam. In your testimony on this matter, you proposed 3 specific categories of disallowances, again, based on the theory that North Carolina Coal Ash Management Act imposes requirements that are not imposed by the federal CCR rule. I think we've established that. You'd agree?
Yes, sir.
Okay. And we can look here in your opening in Table 5-4 that you included in your opening statement.
Yes, sir.
You'll agree with me that the 3 disallowances that you have recommended are all based on the contention that North Carolina CAMA law required the company to take actions that cost South Carolina customers more than they would otherwise have paid under the federal CCR. Isn't that right?
Yes.
Okay. Now, you also said something that was interesting to me in your opening. You said that determining with great precision what the CCR cost increases above and beyond what the CCR federal rule required based on the limited information provided by the company, it's like performing brain surgery with a pickaxe, right?
Yes, I did.
Okay. Well, you would agree with me that when you talked to the North Carolina Commission, it wasn't an issue of whether or not you had enough information. It was enough. The issue you told the North Carolina Commission as to why you couldn't conduct a proper analysis is because you didn't have enough time and you weren't paid enough money. Isn't that right? No,
I think that's a mischaracterization of what I said. What I said, as I recall, now you probably have it sitting there in front of me and I'll probably eat this, but what I remember saying is, what I remember saying was that we didn't have adequate information to make an informed decision regarding cost in North Carolina. But my task here is a good deal different. I'm not being asked to look at all the costs as to whether they're prudent and reasonable. I'm just teasing out for the commission the differences between CAMA and CCR rules. That's my sole purpose here.
Okay, well, you were right, Ms. Whitliff. I'm going to show you something here on the Elmo.
If y'all can read that, you're better than I.
Well, can't get it to zoom.
Okay.
Mr. Erskine's coming up. We could get Scott Elliott. He knows how. Couldn't resist, Scott.
And I'll read that for you, Ms. Whitliff. When you were in the D.C. matter and you were talking about this same issue of what it would have to take to get a difference between CCR and CAMA, you said to do it with a level of certainty and specificity, I believe that the commission would prefer and want to see so they could make an informed decision. I think I'd take a ballpark, a couple $100,000 in about 6 to 12 months. Isn't that right?
Is this testimony from North Carolina? Is that what I'm not sure what this document is that you're showing us up there. Is this testimony in this case or in the North Carolina?
It is in the North Carolina rate case where Mr.
I think we've gone far enough. That is the North Carolina case. That doesn't have anything to do with the case that's being tried here. It's irrelevant. I'd ask that they move on.
Mr. Chairman, if I may respond. This witness has just testified that he didn't have enough information and that inhibited him from providing a competent opinion in this case. I wish to impeach his testimony by showing that in the North Carolina Commission, basically with the same amount of evidence at his disposal, he made no such allegation, but instead he did not have enough time or enough monetary resources. It goes to the credibility of his testimony.
Okay, I'm going to sustain the objection.
Mr. Whitliff, you would agree with me that you have not offered any opinions in this matter that any of the costs that the company is seeking for disallowance are unreasonable or imprudent under either the CCR rule or the CAMA law. Isn't that right?
That was not my purpose, and I did not offer that.
Okay, so the answer to my question is
no.
Correct. I'm correct?
You're right.
Okay. So you must agree with me then, must you not, when I say that if the commission rejects the ORS's position that South Carolina customers should not pay for any increased cost brought about by the North Carolina CAMA law, they must logically ignore every dollar of your proposed disallowance because that disallowance is solely supported by ORS's position on cost allocations between North and South Carolina.
That would be the commission's call.
Now, turning to your recommended disallowance of approximately $316 million at the Riverbend site, you contend that had CAMA not existed, the company would not have incurred any costs at the Riverbend site for coal ash activity because the ash basins at Riverbend are not covered by the federal CCR rule. Isn't that right?
Yes.
And by making this argument, Mr. Whitliff, you agree with me that your contention is that absent CAMA, the company would have left all 5.2 million tons of ash at the Riverbend site as is and would not have taken any activity to close them in place, close them by removal of ash, or use a hybrid closure option. Isn't that right?
I can't account for what the company would have or would not have done.
Well, if you go to your sir rebuttal testimony with me, sir, page 5. Tell me when you're there, please.
Yes. Yes.
There on line 10, when you're talking about Riverbend, you say, given DE's past performance, especially as evidenced by the Dan River ash release, it's reasonable to assume that the company would have continued to do its do-nothing approach, absent any regulation for forcing it to do otherwise. That's what you said about Riverbend, isn't it, sir?
Yes, it is.
Okay. And if the company did what you suggested, Mr. Whitliff, left all 5.2 million tons of that ash at Riverbend, while at the same time closing its basins at Allen, Blues Creek, Cliffside, Buck, Dan River, Marshall, and W.S. Lee, the company would have had to answer some serious questions from residents that live around Riverbend as to why everyone else's basins are getting closed, but theirs are going to stay just like that, wouldn't they?
There would have been some questions to answer, that's true.
You would agree with me that the company would not have had good answers to those questions because even the United States District Court of Appeals called the CCR's rules exclusion of inactive basins, like the one at Riverbend, arbitrary and capricious, when it vacated and remanded that exclusion back to the EPA. Isn't that right?
I'm familiar with the D.C. court decision.
Right. I'm just saying, do you think it would have been an easy conversation for my company to have with our customers to say that at Riverbend, this rule just got vacated, excluding this site, declared arbitrary and capricious. We're just going to let it sit there, see what happens. You think that would have been an easy conversation for my company?
I think that I understand the company's dilemma. What my charter was, what I was hired to do, was to determine what additional costs were imposed. And that's an additional cost. And one of the things that I allowed and recommended to the commission in my testimony and my sur rebuttal is that they be allowed to come back when those rules are done again. And then whatever costs you got, let's put them on the table and let's see what's there. But I've not made any determinations other than at this time, those rules are still the way they are.
Ms. Whitliff, do you think I might have had a couple questions to answer from the North Carolina Department of Environmental Quality, too, if I told them that I'm going to leave that Riverbend Basin just sitting there?
Objection calls for speculation.
Sustained.
Well, we don't have to speculate at all to see what happened to the inactive basins here in South Carolina at the WLS Lee site, do we? Mr. Whitliff, you'd agree with me that the South Carolina DHEC down here, as we've talked about several times, entered into a consent decree for us to close that inactive basin, notwithstanding it was excluded from CCR. Isn't that right?
Yes.
Okay. Now, Mr. Whitliff, turning to your recommended disallowance of about $117 million at the Dan River site, you allege that had CAMA not existed, the company would have not even begun moving ash from that site until October 31, 2020 under the CCR rule. Isn't that right?
Yes, and there's I think give me a second here. The federal CCR rules do have a requirement on the uppermost aquifer restriction, and one of the ponds at Dan River didn't meet that. So that when they stopped sending wastewater streams to the ponds, they then were obligated to initiate closure. And so that happened, that trigger that Mr. Karen referred to earlier, happened on April 4th of 2018. And then going through it, there's a series of, there's a regulation in the federal CCR rules that says you've got to commence closure within 30 days, and he's right on that. The difference is that he wouldn't have been under the high priority closure that required completion of closure, not beginning of closure, completion of closure by April 1st of 2019, and he would have had more time to work on that and take a more methodical approach.
Well, let me back up a little bit. You were aware at the Dan River site there's something called a primary ash basin.
Yes.
And a secondary ash basin.
Yes.
And the utmost aquifer trigger that you talked about under the CCR rule, that applied to both basins, primary and secondary. Isn't that right? Absent any other CCR trigger being implicated, that would have been the trigger mechanism for closure under CCR. Isn't that right?
The information that I have says the secondary ash basin was the one that triggered the regulation. I can't speak to the primary ash basin.
Okay. So that's helpful. So you would agree with me, Mr. Whitliff, don't you, that as to the primary ash basin, where the primary ash is located, that would have had to have been closed sooner than your October 31st, 2020 date under CCR, because another trigger in the CCR rule would happen to make that closure sooner. Isn't that right?
Are you referring to the location restriction, or are you referring to when they stop flowing ash to it?
Yeah, let me put this in plain English as much
Thank
as I
you.
can. So you would agree with me that notwithstanding any other CCR closure triggers that happened at that site, the company was excavating ash from the primary basin at the Dan River site to sell it to the Roanoke Cement Company for beneficial reuse. Because it did that, it would have triggered, a CCR rule would have triggered another date under 40 CFR 257-101 little b little 1 2I, and that 10/31/20 date would have been changed to May 4, 2018, right?
Yes.
So to the extent you've based any of your calculations on a 10/31/2020 date for closure for the basins at Dan River, that would be wrong for the primary basin. It'd instead be May 4, 2018, wouldn't it?
Yes.
Mr. Whitliff, Mr. Chairman, I'm going to try another one, probably at hazard here, and opposing counsel could object, but I'll proffer it for the record, perhaps. Mr. Whitliff, you would agree with me that in the North Carolina proceeding, where you testified in the DEC case about coal ash, you took the same position that North Carolina customers should only pay for cost under the CCR rule, yet you were unable to identify $1 of difference between the CCR rule and the CAMA in that case. Isn't that right?
That was not my charge or what I was asked to do in the North Carolina case.
I see. So if I understand it, Mr. Whitliff, your charge in the North Carolina case was to say there are differences between the CCR and CAMA rule. North Carolina customers should only pay for the CCR cost, but I don't know what that is. Is that what your charge was?
The charge was to assist the Attorney General's office in determining I'm sorry, I don't see a purpose to, it was a different client, it was a different time, and it was a different purpose. I really wasn't hired to divine the cost. I gave it a good shot, but I didn't have the data that would give us the specificity that I would feel comfortable in putting in front of a commission. We got a lot of better information in this case, thanks to the company. There were times whenever it wasn't as on point as what we were looking for, but there was more data to look at, and the cost had actually started to be accumulated into some amount where you could see a pattern or you could see some information there. So I don't think North Carolina on the cost issue is particularly relevant here.
Well, Mr. Whitliff, let's talk about your methodology that you used in that case since you just brought it up.
Now I'm going to object. Why are we going down this whole road again? For some reason, Duke is attempting to retry the North Carolina case. What Mr. Whitliff did in that case has nothing to do with this case.
Sustained.
Mr. Chairman, if I may, not to the objection because I haven't asked a question yet, but when I was going to ask my question, I was going to note that Mr. Whitliff has impeached the methodology that he's actually used in this case in a prior proceeding and called it unreliable and facially challengeable. notwithstanding his testimony where he said his cost disallowance methodology was patently unreasonable and facially challengeable, he's used the exact same methodology before this commission today. So as an expert, he carries his prior testimony and impeachment of his own methodologies with him, and I would offer that it's relevant to impeach the entire calculation methodology he's used in this case.
We'll weigh that and rule on it in the order then.
So am I allowed to ask my question, sir?
Yes.
Thank you, sir. Mr. Whitliff, if you would turn to page 37 of your direct testimony, lines 22 through 23. Tell me when you're there.
There.
On line, you state in that part of your testimony, using the same methodology outlined in my discussion of Buck earlier in my testimony, the weighted average of engineering and planning as a percentage of total for the project cost. And you go on to describe your methodology for calculating disallowances there, don't you?
You give us that page one more time.
Yes, sir. Page 37 of Mr. Whitliff's direct testimony, lines 22 through 23, and then on to the next page on page 38.
Thank you.
Yes, sir.
Ask your question again.
Yes, sir. My question is, you state on page 37 of your direct testimony, starting at lines 22, that for the Buck site and for the Dan River site, the methodology that you used for determining your proposed disallowances is what you call the weighted average of engineering and planning as a percentage of total project costs for, and you go on to describe the sites. Isn't that correct?
That's correct.
And now to my question, isn't it true that you told the North Carolina Commission that that weighted average cost as a percentage of engineering total was unreliable and would have been challengeable on its face, and you just could not get comfortable with it?
That just doesn't sound like me. Now, you're probably going to have a piece of paper there that's going to say that I said exactly that, but I'm telling you, I don't remember saying that. What I will say, and yeah, there you go. What I will say is that we used Karen's stated engineering and planning process, that it was their intent and desire to do engineering and planning simultaneously across the entire fleet, and that they were looking at that so they would get economies, they would get a standard approach, they would have some standard ideas about how to approach these things. And so when you have these high priority sites, the high priority sites are loaded. I'm so sorry, I talk with my hands and that's bad. They're loaded on the front end, and but if you look at the four plants, Allen, Blues Creek, Cliffside, and Marshall, those plants were CCR compliant. And so what I was doing there was trying to establish what kind of a baseline engineering planning, if you were on the same schedule, would you have at Dan River and Buck as you would at these other four plants. It's not a precise, but it is my attempt to try to get to some sort of reasoned conclusion about what these additional costs would have been in terms of above the engineering and planning baseline, how much more did you spend because you had to do it faster. Not that that would be disallowed, it's just that is a matter for another day.
Mr. Whitliff, I'm close to wrapping up. last line of questioning here. In your SIR rebuttal testimony on page 3, starting at lines 3 through 5, you discuss a mismanagement penalty that was exacted upon Duke Energy Carolinas and the North Carolina Commission, isn't that right?
Yes.
And you state that the fact that a very significant management penalty was imposed by the NCUC can only lead to the conclusion that my arguments regarding the company's actions were strongly considered by the NCUC. Isn't that right?
That's what it says.
You would agree with me, though, if I go to the Duke Energy Carolinas order from the North Carolina Commission on page 266. Speaking about your testimony, the North Carolina Commission said, quote, "Indeed, AGO witness Whitliff was not able to specify exactly how the company should have acted differently in managing its coal ash to be consistent with the industry, or at which sites it should have taken those actions and how much those actions would have cost the company. Witness Whitliff also presented no credible evidence showing DEC's engineering and design of its impoundments was not consistent with industry practice and regulatory requirements at the time, other than his own subjective allegations." Would you agree that you went back? That's what that order would say, sir, if you looked at it, subject to check?
Well, I'm trusting you to read it.
Okay. And you would also agree with me that the penalty that the North Carolina Commission levied against the company was just under 13% of the amount of costs that the company requested, which is nowhere close to the about 54% you've requested in this case. Isn't that right?
Yes, they had $70 million in penalty.
So if the commission was inclined to do what the North Carolina Commission did in that case and exact a mismanagement penalty, it wouldn't be for the almost 54% you've asked for. It would be a much lower figure of 13%, wouldn't it?
Let me put this on pause a little bit, because I think that what we're doing is we're getting a little far afield, because you're acting like I'm saying you're never going to get the money. What I'm saying is that the CCR rules allowed a longer time. They allowed a different place to start with, and they could come back and recover those should the CCR rules be changed to allow them to come back in and ask for relief. But I'm not saying out and out today that you don't get anything. That's just, so first of all, it's not my call. It's not my recommendation. What I'm saying is, on Riverbend, I'm not ready for being considered in these proceedings because the rules haven't changed. With regard to Buck and Dan River, those costs, when and if the rules change, they can come back in and recover those costs. It's not like forever. I don't understand. I mean, you're asking me a question that makes it sound like today is the only day that would ever be visited.
I appreciate your time today, Mr. Whitliff. Nothing further, sir.
Thank you. Any other cross for Mr. Whitliff? Commissioners?
Mr. Chairman.
Yes, sir. Sorry.
Mr. Whitliff, I just have some real basic questions.
Good. I could use some.
Not at this high level I've heard so far this afternoon. I've got some concern that even with all of the testimony so far on the record that the ratepayers are simply paying more than they should for these matters. So if you would give me some comfort that the ratepayers should be paying anything at all, I'd appreciate it. Can we agree that Duke was under a duty to prudently operate and maintain these coal ash ponds?
Yes.
And can we agree that throughout the life of these coal ash ponds, that Duke's ratepayers have been paying in rates some amount to compensate Duke for the cost and expense of maintaining the coal ash ponds?
Objection, Mr. Commissioner. Mr. Chairman, Mr. Whitliff has on numerous times stated that his engagement here was just to calculate differences at specific sites. I've had my questions not allowed on that same theory, so this is beyond the scope.
Mr. Chairman, this is open cross. I'm not asking about the nature of his engagement. I'm asking him some just basic questions.
Okay, overruled.
Thank you, sir. So again, can we agree that that Duke ratepayers have been paying through rates an amount to cover the cost of the operation and maintenance of these coal ash ponds?
I think that's a reasonable expectation.
And can we agree that were these coal ash ponds prudently maintained and prudently operated, that Duke might have avoided some, if not all, of these coal ash remediation costs?
Objection calls for speculation and assumes facts, not in evidence.
Sustained.
Well, we can agree, can we not, that that a coal ash pond, certainly operated as intended, should not fail, absent some act of God.
Yes, I think that's reasonable.
All right, and I think I understand from your testimony in this case that that Duke had plenty of notice over the years of the dangers associated with the failure to operate the coal ash ponds in a prudent manner. Can we agree with that?
Please ask that again.
Well, for instance, and I think you testified on page 10 of your testimony that under the Clean Water Act of 1972, these coal ash ponds were required to be operated in a manner that didn't spoil the state or nation's waters, correct?
Yes.
And then in accordance with 40 CFR 122.41, Duke had a duty to comply with its NPDES permit, didn't it?
Yes.
And Duke had a duty to mitigate any and all damages to the environment associated with its NPDES permit, didn't it?
Yes.
And Duke had the obligation under its NPDES permit for the proper operation and maintenance of the coal ash ponds. Am I correctly characterizing your testimony? And so as far back as 1979, North Carolina established rules to protect, maintain, preserve, and enhance the quality of the groundwaters of the state of North Carolina, did it not?
Yes.
And we already understand from the terms of its NPDES permit that Duke's failure to properly operate and maintain those ponds could spoil or contaminate the waters of North Carolina. Did we not?
Yes.
And I think you testified that in 1979, the Los Alamos report put the nation's utilities, including Duke, on notice of the dangers of the improper maintenance and operation of coal ash ponds, correct?
Yes.
And again in 1988, in an EPA report to Congress, similarly sounded the alarm about the dangers associated with the improper operation and maintenance of these coal ash ponds, correct?
Yes.
And as I understand it, the federal coal combustion residual rule was, in its origins, dates back as far as October 21 of 1976. Is that correct?
Yes.
And then for a real-life example of what could happen if a coal ash pond is not properly operated and maintained, on December 22, 2008, a dike used to contain coal ash at the dewatering area of the Tennessee Valley Authority Kingston Fossil Plant in Roane County, Tennessee failed, correct?
Yes.
Mr. Chairman, object, irrelevant. He's given us a history lesson of coal ash that does not go to any issue Mr. Whitliff has talked about. No allegation of imprudence, no allegation of unreasonableness. He simply noted differences between two existing rules. Way out.
I'm going to overrule, let him proceed.
Thanks, sir. And in fact, at the Kingston plant, approximately 5.4 million cubic yards of coal ash was released into Swan Pond, correct?
Yes.
And so it's fair to say, is it not, that Duke knew or should have known of the dangers of the improper maintenance and operation of its coal ash ponds?
Yes.
And when was the Dan River spill?
February of 2014.
And so my question again is, Mr. Whitliff, had Duke heeded the warning signs that you and I have discussed here this afternoon, could Duke have prevented some or all of these contaminants spilling into the Dan River or elsewhere?
Objection calls for speculation.
Sustained.
Now, you testify as to the Lee station in Anderson County, South Carolina. Do you recall that?
Yes, sir.
And certainly the Lee station is an outlier in that it's the only South Carolina facility involved in this docket, correct?
Yes.
Now, I think as I understand it, you have studied a number of aspects about the Lee Station facility, but one of which being the existence of a consent order entered into between Duke and DHEC concerning the Lee Station, correct?
Yes.
And as a part of your investigation of this matter, you had an opportunity to review all the DHEC documents, or at least the relevant ones, including the consent order, correct?
Yes.
And to be clear, the consent order in this case, in this matter, was executed last by the DHEC authorities on September 29, 2014. Do you recall that?
That sounds right.
Yes, sir. And I'd like to show you a copy of that DHEC order and ask if you recognize it.
Yes.
Thank you so much. Mr. Chairman, I apologize. I only have one copy of this, but I'd move this DHEC order into the evidence of this case at this time.
It will be entered as Exhibit 35.
Thank you, Mr. Chairman. Now, Mr. Whitliff, this order, just for the record, Exhibit 35, is captioned In Re Duke Energy Carolinas, LLC, W.S. Lee Steam Station, Anderson County. Do you see that, sir?
Up there at the very top? Yes.
Yes, sir. And it's labeled a consent agreement, is it not?
Yes, it is.
And it carries a consent agreement number of 14-13-HW. Do you see that?
Do that.
Now, this is by its terms an agreement, not an order. Is that correct?
Yes.
And you're aware, are you not, of the fact that DHEC, in the appropriate case, can actually issue an order requiring a regulated utility to take some step or take some remedial action. Are you not?
I am.
And you understand there's a difference between an order, which compels an act, and an agreement, which is a negotiated document. You understand that, don't you, sir?
I do.
Now, the findings of fact in this document are relatively brief. And finding of fact 1 provides that Duke owns and operates W.S. Lee Station to supply electricity, correct?
Yes.
Now, number 2 provides that prior to 1974, CCR was placed in the inactive ash basin, which is an unregulated basin located south of the power plant. You see that?
Yes, I do.
And so this ash basin was not regulated by DHEC, according to the finding in this order, correct?
No.
And also we've learned that this ash basin, I think because it's inactive, is not subject to the federal rule regulating CCR. Is that correct?
That would depend on whether if it's an existing inactive basin at an inactive power plant.
And it would appear that it was both, does it not, from this finding?
At first blush, yes.
And in fact, I think Mr. Karen testified to that, did he not?
I don't know. I'll have to check.
Let me refresh your recollection, if I may. I don't have it all highlighted, but this is from Mr. Karen's summary when he testified just where you're seated a few moments ago. First, I disagree with ORS witness Wycliffe's erroneous conclusion that absent CAMA, the company could have left its ash basins at Riverbend untouched indefinitely because those basins are not covered by the federal CCR rule. Do you see that language?
Do.
And then he further testified the position that DE Carolinas could or would have taken a do-nothing approach for Riverbend CCR units when similar basins at the company's South Carolina W.S. Lee Station that are also not covered by the federal CCR rule were being excavated is wholly unrealistic. You see what I've highlighted there?
Do.
So Mr. Karen, at least, tells the Commission that the W.S. Lee station here in Anderson was not covered by the federal CCR. You would not disagree with Mr. Karen, who testified for the company on this issue, would you?
No.
Now, I would like to go just a little further. Paragraph 3 says CCR was believed to have been used in the past as a backfill on the Asheville area, which is located near the inactive ash basin. You see that?
Do.
And then on May 1, 2014, Duke Energy initiated geotechnical characterization of the inactive ash basin. Do you see that?
I do.
And so that language says that the first conduct or action taken with W.S. Lee was taken not by DHEC, but by Duke, correct?
It appears so, yes.
And then on May 30, 2014, Duke Energy submitted a plan for the geotechnical characterization on the Asheville area. Do you see that language?
I do see that.
And in both cases, paragraphs 3 and 4, it is Duke taking a step to start this consent agreement process. Do you see that?
I do.
Now, do you understand that here in South Carolina, that with respect to a regulated activity, an activity regulated by DHEC, that if there's a violation of a permit, DHEC will institute a corrective action. Do you understand that's how DHEC works here?
Yes, I'm familiar with that process.
But what we know here about the Lee Station is that at least 2 engineering firms engaged by the company advised them that no remedial action was necessary for the Lee Station. Is that correct?
Objection assumes facts not in evidence, and counsel is testifying.
Sustained.
Well, would it not be the case, Mr. Whitliff, that if DHEC saw no need to institute this consent agreement, that would have had to have been initiated by Duke? Isn't that logical?
My experience in Texas with enforcement actions is you can voluntarily disclose and come in and work with the agency to take care of a problem you've self-identified. And those would be done under consent agreements so that everybody understands what's going on and how you mutually agree to proceed. So otherwise, you're on the business end of an enforcement order.
All right. And so in this particular case, the South Carolina case, we have the company coming forward to institute a consent agreement with the regulator to excavate these ponds. Is that your testimony?
Yes.
Now, you heard a couple of witnesses here previously describe this DHEC consent order as South Carolina policy. Do you recall that?
Yes, I do recall that.
Well, basically, this consent order is an agreement between Duke on the one hand and DHEC on the other hand, wherein DHEC has consented to Duke's excavating this coal ash basin, correct?
Yes.
And you're not aware of any statute in South Carolina that required DHEC to require Duke to remediate this coal ash, are you?
No. There are some regulations that are in place, and DHEC is in charge of making sure those regulations are complied with.
Well, if you look at this order, at the top it reads, the department has authority to implement and enforce laws and regulations pursuant to the South Carolina Hazardous Waste Management Act, and it cites a code section. Do you see that, top two lines?
I do.
But Mr. Caron testified in response to a question by one of the commissioners that this coal ash isn't hazardous waste, is it?
It's not hazardous at this time.
Yes, sir. And so, again, DHEC may have some statutory authority, and it may have bootstrapped itself into this agreement by this language, but the coal ash is not hazardous.
No, sir.
So we know that. The DHEC, the Anderson site, was not regulated by DHEC, correct?
Anderson site?
The W.S. Lee Steam Station in Anderson County. I beg your pardon.
I'm sorry. W.S. Lee. Thank you. Yes.
Yes, sir.
Yes.
We understand it wasn't regulated by DHEC. We understand that the W.S. Lee Steam Station in Anderson County was not regulated by the federal CCR rules, correct?
Yes.
And we know that that the coal ash is not subject to regulation by the Hazardous Materials Act of South Carolina, correct?
When I talked with the DHEC officials to kind of get an explanation of how they got into the consent agreement, their explanation was that they basically not enforced, that's the wrong word, that they pursued it according to the solid waste regulations of the state of South Carolina, for which they have delegation, is my understanding. And they also looked at the Clean Water Act and PDS stuff as well. So I don't know the hazardous piece, but I know that they were looking at the solid waste regulations.
And if you had the same conversation with the same person I did, you were also told that even though they may not have ruled Duke in to clean up this, or ordered Duke to come forward and clean up this coal ash basin, that they weren't going to look a gift horse in the mouth.
Objection, hearsay, calls for assumes facts, not in evidence. Counsel's testify.
Sustained.
If I may be heard, he testified to what the officials told him, and I was simply pursuing that line of questioning.
Okay, you can proceed.
So I think the question was, if your conversation with the DHEC employee, if it was like mine was, that the DHEC employee said that with Duke being voluntarily in front of them to excavate and remediate this coal ash basin, they weren't going to look a gift horse in the mouth.
No, they weren't.
Thank you. I have no further questions.
Thank you. Any other cross? Commissioners? Commissioner Howard?
I'm fine. I have no.
Thank you. Commissioner Whitfield?
Thank you, Mr. Chairman. Got just a couple for you, Mr. Whitliff. Chairman's warning me we're on time a little bit, so let's try to make this brief. Let's use that pickaxe you were talking about and just pick into it for a quick second on a couple of questions. I was going to ask you about the 8 plants. We don't really need to get into the location of Lee. Obviously, it's in South Carolina, but the other 7 plants, you did say you visited them. Could you briefly discuss the locations, and maybe we can look at the basins that some of them I know ultimately go into the DEP territory. So if you could just briefly mention the locations of the other ones, not Lee.
I got it. We visited Cliffside, River Bend, Buck, Allen, Marshall, Blues Creek, Dan River. Did I capture them all? All 7? Or did I miss one?
I think you got them. North Carolina ones. Yes, sir. Go ahead.
Okay. Obviously, Cliffside's just inside the border. River Bend's maybe 10, 12 miles inside the border in North Carolina. A couple of those watersheds do come into South Carolina. I didn't, when you get past that, it's a little more difficult to assess there's an impact. That's where I thought you were going with that question.
Right, and I realize you're from out of state even when it comes to North Carolina, so you've at least acknowledged they impact some of the basins, not only in the Duke Energy Progress Territory, but also in South Carolina.
Yes, sir.
Real briefly, without rehashing everything you've done today, what method is used to calculate the CAMA-related costs to South Carolina ratepayers?
Basically, what I did was a system-wide impact. And then what I understand is there's an allocation, and I've heard 24%, 25% talked about here. That wasn't mine to determine. I'm just basically saying this is a system-wide impact and increases caused by CAMA over above what the CCR rules are. So if there's an allocation of 24, 25%, you'd multiply that times whatever is y'all finally reach, and then that would be the impact to South Carolina customers. That's the way I understand it would work. I may not be pristinely correct, but that's the way I understand it.
Okay, and how does North Carolina CAMA differ from equivalent laws applicable in both North Carolina and South Carolina?
Well, in my direct testimony, I list several. Actually, I think there's close to 8 there. If you'll just give me a second, let's see if I can find it quickly. Here it is. Because there's no CC, I mean, they've adopted the CCR rules in South Carolina. So from my understanding and my discussions and research, what I've been able to determine is that there are differences between CAMA and the CCR rules in the closure mandates. CAMA doesn't allow cap in place for anything but low priority sites. And then if you have a high priority site, now you're on an accelerated timeline to get it closed, and excavation into either an on-site landfill or to some other off-site landfill is pretty much your choices. Now, with the exception of, let's see, that's closure. That's the mandate. Then there's closure methods. Again, you're only allowed cap in place at low-risk sites, and that's one of the reasons how Allen, Blues Creek, Cliffside, and Marshall were allowed to close with cap in place instead of something a little more costly. So that's a principal difference. Compliance timing is another. That the CAMA rules require accelerated timing for high priority sites, and then there was the and that was basically they were having to complete those by August 1st of 2019. Then the applicability to inactive sites, because the CCR rules apply only to sites that were active as of April 17th, 2015, Riverbend wasn't impacted by the CCR rules, directed for closure under CAMA.
I see that on your chart. Yes, sir.
Okay. And the beneficiation requirements are something that's just not mentioned at all in the federal rules, but are a requirement for 300,000 tons per year at each of 3 sites. And the two are Cape Fear and HF Lee and DEP and Buck and DEC. Then there's the conversion to dry ash disposal. CAMA requires that if you're going to be an active plant going forward, whereas the CCR rule, while itself doesn't say anything about it, there is a federal requirement under the Steam Electric Effluent Limitations Guidelines that basically proposes to require that conversion. Then there's the high priority sites. We've already talked about that. But those are the principal differences.
Mr. Whitliff, I don't know if you heard about any of the night testimony, but couple of the witnesses at some of the night hearings complained about the excessive amount of trucks and equipment running the material from. I'm coming back to W.S. Lee in South Carolina now, coming down 85 and tearing up the roads and that sort of thing. And as commissioners, we're not allowed to visit the site. We're a judicial body, and you are allowed. You did visit the site, and you're an engineer. In your opinion, as an expert opinion as an engineer, what would have been the best remediation procedures for that facility, since you did visit the site and that is your area of expertise? And I know when you're on a hurry up scenario that's what they did, but in your opinion, could you offer any opinion on that?
Well, at W.S. Lee, which is not W.S. Lee, H.F. Lee.
Lee, right on the Anderson-Greenville County line on the Saluda River. That site, yes, sir. South Carolina.
All right. Oh, well, I'm sorry. No, that one was not. They hauled some stuff off, but
talking about where they trucked it off to Georgia.
Oh, that part. They did truck it off to Georgia. And are there better ways to do any of these things? There's, what is that saying? You can have it cheaper, faster, or right. You get to pick any two. And so if you're mandating folks to get it, if they're mandated to get it off the site and go somewhere with it, then that's expensive. It's more expensive. And you do have those attendant issues with the traffic, with the safety on being on the road. I mean, those are material issues. I haven't given that a lot of thought as to what a better solution would be at W.S. Lee, because it was a negotiated consent agreement with the state.
With DHEC, yes, sir.
Yes, sir.
All right, thank you, sir. That's all I have, Mr. Chairman.
Any other commissioner questions? Okay. Recross.
Yes, sir.
Redirect, I mean. Something. Okay. Mr. Whitliff, appreciate you being here, and thank you for your testimony, and you are dismissed.
Thank you, sir.
And we are adjourned. 10 o'clock.